Hey everybody, hope you enjoyed your break. This is going to be the last substantive section of our CLE here today on sex crimes. I'll be focusing myself on federal sex crimes, and then at the end of the presentation today, we are going to have a question and answer session, kind of like a roundtable with all of the attorneys at the firm who have presented to you today, just to kind of bounce ideas around, talk about some war stories and some great results we've gotten for our clients in this realm of sex crimes, both state and federal. And we think it's going to be a great experience, all said and done. So just a bit about myself. I'm one of the partners at the Rossen Law Firm. Again, my name is David Tarras. I'm the head of our federal criminal defense practice here at the firm. Our firm has federal cases throughout the country. Primary area of focus is the Southern District of Florida, which covers everything from Key West to Fort Pierce. The major areas, the major hubs, so to speak, of the Southern District of Florida would be Broward County, Fort Lauderdale office, West Palm Beach, and the Miami-Dade. And we practice in all those areas. Our firm is based in Palm Beach County and based in Fort Lauderdale, but we kind of hate it, and we love what we do with this. So being that I'm the head of the federal criminal defense practice here at the firm, what I'm going to be speaking to you about are federal sex crimes. Now, a lot of what you have already heard from my amazing partners that they have presented to you is still very much applicable to the federal system as far as trial, the way we fight cases, the initial client interviews, the investigations, motions, the law, because a lot of the law in state court and certainly, of course, in federal, and in state court is structured off of the federal rules of criminal procedure and federal rules of evidence. But what really is going to be my focus for the purpose of my portion of this CLE are the nuances of federal court when it comes to sex crimes, and kind of the nuances of federal court in general, because they are one and the same in a lot of ways. Again, a lot of federal is like state, but a lot of it is different. And primary differences that really don't relate specifically to sex crimes are the discovery tools, the timetables, the agencies and law enforcement agencies that are investigating federal sex crimes, as opposed to a local county, state law enforcement or sheriff's office. Here in federal sex crimes, and the firm is dealing very often with the FBI, with Homeland Security, Secret Service, the Postal Service, especially in situations where, as it relates to federal sex crimes, that certain unlawful material, such as child pornography, which we'll be discussing, or other obscene material, is transported and mailed across state lines, and also individuals who are using highways and interstate methods to travel across state lines is how we start getting into the realm of federal. Of course, across the board between federal and state, we're talking about, when a federal sex case, some of these amazing tools that my partners had discussed with everybody already don't apply in federal, and that makes it very challenging. For one, we don't get depositions in federal. The discovery tools that we have in federal, we have the motions, we have the ability to challenge evidence. Biggest difficulty being, of course, that we don't have depositions in order to gain a lot of our best ammunition in filing these motions and digging into these cases. So we have to adapt and find other ways. It's extremely rewarding, federal sex crimes, but it's also very difficult, and you have to really know what you're getting into. There's lots of different kinds of federal sex crimes, spanning vast different amounts of statutes. The ones that we're going to be focusing on today, and a lot of this with these charges will apply to state court as well, and how you go about your state practice in defending sex crimes. But our major focus is going to be child pornography, child sexual exploitation, and the use of materials resulting or being created or distributed from child sexual exploitation, and that is essentially child pornography. There are a lot of different statutes within the federal system that cover child pornography. We're going to be taking it from a more broad perspective. I could focus for an hour each session on each one. But one of the reasons why I think it's going to be most beneficial in the sense of child pornography and to focus on that in the federal system is because that aspect of it is cyber sex crime, but also child pornography in the federal system has by far the most nuances. It is would be the biggest shock going from how you may have handled child pornography cases in state court to federal court, and a majority of that, which we're going to be discussing, has to do with the sentencing structures between federal and state court, which are vast. I am still, with all the experience I have in this, still learning more and more every day. So this should be a great start, but continue. If this is something that you're interested in and representing clients who are facing such serious charges in federal court, then you really, really have to do your homework. You have to be prepared, because these are very, very technical aspects of the law that you deal with in the federal internet crime, cyber sex crime community, so to speak, of charges. So let's jump in. Okay, so state versus federal. Federal courts are governed by the United States Constitution and Title 18 of the United States Code. State courts are governed by both local state laws as well as federal. This does result in several differences that create very large impacts for our clients who are facing federal charges as opposed to state, and again, mostly as it relates to child pornography offenses. A lot of what I'll be talking about is applicable to both, but a lot of what I'm going to be talking about are, the specific nuances in federal court. The outcomes when a case does go federal are drastic when it relates to sex crimes in general, because the sentencing structure, the resources that the federal government has are vast, far beyond what local law enforcement or state law enforcement has, as well as the technical technology that is available to the FBI and is available to Homeland Security and DEA, whoever might be investigating this case or a federal sex crime. So very, very, very important to consider these things when deciding whether or not you want to take on the endeavor of doing federal sex crimes in court, in federal court specifically. So the laws do overlap. The U.S. Constitution does give federal courts basically the last say. And what's interesting about that too is that federal courts ultimately, and federal prosecutor's office, whether it's the U.S. Attorney's Office or if it's Main Justice and Department of Justice based out of Washington, they get to pick and choose what cases they want to bring. And it's really important when you're thinking about federal sex crimes. How do we determine that? How do they pick and choose? Because going back to what I believe my partner Adam had said, this whole process of criminal representation starts at the initial meeting with the client, and you have to be able to set your client's expectations. There are very few charges, and child pornography being probably the most common, along with maybe felon in possession of a firearm state charges that have I would say, high likelihood, depending on the facts of the specific case, as to whether or not the feds are going to come in even sometimes after state, local law enforcement has investigated a state crime related to child pornography, and charges have been brought in state court, and then the feds will come in and they'll say, actually, no, that's a case that we would like to take. And we're going to talk about the reasons why they would do that. But something that I always love to do when I get a case, and if the case comes to me, because a lot of cases do start with state investigations and sometimes even state charges. But to me, if you do your homework and if you have the experience, you can kind of get to a point where you can see, is this a case that I should be worried as the attorney about the feds picking up? And if so, if the feds do pick up the case, you have to be able to inform your client about repercussions of that will be, because for sex crimes specifically, they are drastic. And there are specific reasons we're going to talk about why the feds pick up certain sex crimes that a state court could prosecute as well, mostly as it relates to child pornography again, because some of the other crimes that we see in federal court are a bit more obvious as to why they would. For example, if an individual, if our client is alleged to have been attempting to solicit a minor in another state for sexual activity or sexual exploitation, and they cross state lines to attempt to go meet that minor for the purpose of engaging in a sexual act, whether it's a federal act or a state act, according to the statute, that's pretty clear why the feds would pick it up, because crossing state lines, okay? But it's not always so clear when it comes to cases involving the internet, and the main reason for that is because the internet is the internet, and the internet is vast. Okay, I don't have to belittle that point. It's global. There's so much technology in play. Experts are so important in this case. I'm not going to try and, you as the attorney have to know enough that you can speak like an expert to your client. But at the end of the day, when you're getting so technical with technology that are involved in these internet cybercrime cases in federal court, having an expert to assist you is extremely important. But again, when it comes to the internet, it's kind of like the Wild West. You may have heard of the dark web, different chat apps, Discord, Kick, all kinds of different online forums where people can share information. One of the big ones that we're dealing with right now, and we're going to talk about some more, is peer-to-peer networks, what maybe we used to, the primary ones being Napster or LimeWire back in the day. There are other versions, and even actually, not LimeWire itself is making a comeback, and what we call peer-to-peer is becoming a huge challenge for child pornography, sexual exploitation defenses in federal court, because the feds do have the opportunity to infiltrate those, and that raises a lot of concerns that we're going to talk about. Typically, when we're talking about, again, how do the feds pick and choose, really, there are certain general tenets of federal prosecution and federal charging decisions when a prosecutor is reviewing a case, a federal prosecutor, and saying, is this one that I want to charge on top of the state court having charged them? Basic tenets is, first, would picking up this case, would proceeding with this prosecution serve a substantial federal interest? That is tied directly into sentencing of federal cases and the enhancements, the guidelines that we will be speaking about later. Every child pornography case that involves the internet is almost always going to meet that criteria, because the feds are very overwhelmed with these cases. They're growing as the internet grows, as the dark web grows, as just the access that people have to each other over the internet in all different kinds of forums and ways. The amount of prosecutions being brought for child pornography offenses in federal court are growing, and the system is adapting, but not in every way that you would expect. A little cliffhanger. Anything involving interstate communications. So it's more clear if we have a child pornography case that involves distribution or transportation of child pornography across state lines, which when we're talking about the internet is usually pretty easy for the government to establish. Not always, but pretty easy. It's much more easy if someone's going into another state to meet with a potential alleged victim of, or is alleged to have gone across a state to meet with somebody for a sexual act or to entice them or at least attempt to. A little more clear why the feds would get involved. But more than anything, when distinguishing between state and federal sex crimes, it's really about, can the case itself, is it so substantial, is the evidence of child pornography so substantial that it will qualify for the vastly stricter sentencing scheme, including minimum mandatory penalties, that is offered by the federal sentencing structure, both in the sentencing code, which sets the minimum and maximum penalties, and then also the United States guidelines is a separate sentencing structure that we have in federal court, which is more of a mathematical computation. Cases that I see that start off in state court, or that I see the feds picking up in the realm of federal sex crimes or child pornography in particular, are usually involving a lot of videos, because that meets a certain sentencing enhancement under the guidelines, which we'll talk about a bit more. The number, the content of the videos, the age of the minors that are present in these videos or images, the type of device involved, whether it was a mass distribution, any kind of case involving distribution or a scheme to distribute child pornography. We're already pretty much getting into the realm of federal, and also whether the case just basically has enough where the federal sentencing is going to be so much higher. And we wish it wasn't that way, of course, as defense attorneys, but in general, when they see a case that might be in state court that says, look, majority of state court child pornography offenses are third-degree felonies. In the state of Florida, that's punishable by 5 years. In federal court, the same charge, if there are enough images, if the material fits within these aggravators, these specific circumstances, such as the material involves pain or torture, or sadist or masochism, these different enhancements that exist and will go through them, then they're much more likely to bring that, because they're saying, look, this individual in state court could very likely, if it's their first offense, get maybe probation and sex offender treatment for this. At the same time, in federal court, we're talking about years in prison, possibly even involving minimum mandatories. For example, state courts do not have any minimum mandatory sentencing. A minimum mandatory sentence is where the judge does not have discretion if a certain charge is met or certain factors are met under a sentencing code to give any less. These really don't exist in state court for child pornography offenses. In federal court, almost all child pornography offenses have minimum mandatory sentences. The maximums in state court, usually 5 years. The maximums in federal court can be anywhere from 20 years in majority of cases, upwards of life, depending on a person's history, depending on the specific sentencing aggravators that are in place. Okay, so again, all reasons, things to consider, things to know about why a federal sex crime might go federal as opposed to state. Also, something I want to address quickly is how do these, and we're going to talk about investigations a bit more, but how do these cases come about, okay? And I say cyber, okay? Cyber is basically the concept of internet, easy for them to say cyber, federal territory, okay? Now, National Center for Missing and Exploited Children. This is a very common way that any case, state or federal investigations or prosecutions into federal sex crimes, specifically involving the sexual exploitation of minors or materials that are created based on the sexual exploitation of minors, such as child pornography. We call it NCMEC, is National Center for Missing and Exploited Children, is a huge factor here. So what happens with NCMEC is a cyber tip, which is an investigative lead, is generated by NCMEC. NCMEC is a nonprofit organization and provides services nationwide, nationwide for the purpose of trying to protect children and to weed out child pornography on the internet. There are federal statutes that say that NCMEC has specific mission and that internet service providers, whether it be Google, Yahoo, all different kinds of providers, have a federal responsibility. Any electronic communication service provider that obtains knowledge, and they do this by different ways, that obtains knowledge, of a child pornographic image being on their site, or that they come across it when they're doing their standard reviews, which every single internet company, Google, they have to do this. If they come across this, they have to report this to NCMEC. They have no choice. What happens then is that NCMEC has a massive, massive database of child pornography images. NCMEC runs whatever Google has sent them, across their database, and then that's when the process really begins. Because it's actually a penalty, a federal criminal offense for an electronic or internet service provider not to provide information related to a NCMEC cyber tip. So super, super important to understand how NCMEC works, because you're going to see this as the beginning of almost all of your federal child pornography cases. So, as I kind of already said before, federal courts are likely to take cases where a crime involved activity that crossed state lines, including the use of the internet. The other major charges that we see in cases like this are buying or selling children, not the most common charge, for the purpose of sexual exploitation. Online solicitation of a minor is a big one, especially if the individuals are a cross-state charge. This is if you think of To Catch a Predator. Technology has kind of weeded that out, and there's been a lot of issues with that, but that's the traditional online solicitation of a minor circumstance that we see, and it still goes on very often today. And we can talk about that a bit more. There is still traditional sex crimes, such as aggravated sexual abuse, rape, other charges that can be federal. Usually it involves some sort of involvement with interstate commerce or interstate travel, crossing state lines, still going to meet somebody somewhere. All right. Otherwise, we're really talking about much more likely staying within state court jurisdiction for that. One of the biggest difficulties, again, one of the primary crimes that we're talking about: child pornography, online solicitation of a minor, sex trafficking. Sex trafficking of minors, in particular, is still a rare charge, but it is one of the most serious charges that we see. And if it's crossing state borders, if these children are being brought or enticed across state borders, and these include attempt as well, even if the child is never brought, even if the person on the other end is a undercover officer. Sex trafficking of minors is a major, major federal offense. Very difficult to defend against. We do it. We do it successfully, but the penalties in federal court are very, very severe for these offenses. Another thing about dealing with federal sex crimes and differentiating from state court is this process of the grand jury. So in federal court, you need a grand jury investigation. Okay, you have to be able to produce an indictment from a grand jury in order to bring criminal charges. That is, unless you're a defense attorney, unless myself and my client have been notified early enough. If an investigation started early, best case scenario, when our clients have an opportunity to proactively come and seek us out and say, look, I was contacted by an FBI agent who wanted to come and speak to me about something that he saw on my phone, or a cyber tip that he had received from NCMEC or from Google. And that can happen in so many different ways that we'll talk about. But to obtain a grand jury investigation, state court prosecutors, the amount of investigation that has to be done, it's not even remotely the same, because there's still sufficient investigation, definitely sufficient investigation, but once the prosecutor is given the investigation over to them by the investigator, whether it was sheriff, or detective. A lot of detectives are part of, even in state court cases, are part of what's known as ICAC unit. ICAC is it's Internet Crimes Against Children. There is a very large national task force that exists, which a lot of the detectives we deal with in state court and a lot of the FBI agents that we deal with in federal court are both part of ICAC. And what that is, it's a cooperative collaboration between state and federal law enforcement for the purpose of protecting children and protecting and stopping human trafficking. It's kind of a human trafficking task force in and of itself. So ICAC, even if it's on a state level, they have substantial resources, very substantial resources. It's something that we have to deal with, both in state and federal cases. But this investigation that is completed here, if it's going to federal court, then there has to be enough, and grand juries kind of are rubber stamps. There just has to be a reasonable likelihood of conviction. The defense attorney is not involved whatsoever, but they do have to have enough information already through the investigation to bring it to a grand jury to get charges and not get embarrassed as a federal prosecutor by not being able to get a grand jury. So what that means is that by the time a case is charged in federal court, the case is very, very underway, usually. And there's a lot of strong evidence because a grand jury of our peers has already reviewed the evidence and decided that there's enough, as opposed to in state court, just the prosecutor reviewing it and signing off on what's called an information or a charge in that way. So the reason we're going to have a major focus on child pornography here is because it is one of the most prominent federal offenses, period. It also happens to be a sex crime, which is the purpose of our investigation today. There is a significant amount of data, which is very helpful to defense attorneys, very helpful regarding child pornography. In 2021, which is the most recent report, which is provided directly by the United States Sentencing Commission, and they are the ones who reform and make the United States sentencing guidelines. It's by far the most common federal offense. It's been consistent like that for a while. Just as a stat here, roughly 58,000 total federal offenses reported in 2021. 2.1% of all offenses were child pornography. That's a huge number. There's thousands of federal crimes. So we're talking about here only drug offenses immigration offenses, firearms offenses, fraud offenses, and robbery had more. And robbery kind of goes back and forth, but we're right there as far as federal sex crimes, specifically child pornography offenses. That's a huge portion of the total cases that are being prosecuted in federal court. So talking about the types of child pornography offenses generally, being that child pornography is going to be our focus here. We have Title 18 of the United States, the United States Code. I believe it's Section 116, 110, 116. One second, let me not get that wrong. Excuse me, 110. So 110 lays out the child pornography offenses that we have. And what we are focusing on here is possession, creation, which we call production, distribution, transportation of child pornography. Now, I could spend 5 hours breaking down each individual statute. Okay, federal law prohibits variety of offenses as it relates specifically to child pornography. These are the major categories that we deal with. Okay, distribution is the one that is most interesting. There's been the most debate for decades regarding because of some things we'll talk about in the way that the language is written in the statute and the way it's interpreted in the guidelines. Distribution and receipt, as well as possession. Possession, of course, is the kind of the big one in general and the most prevalent for mostly as it relates to sentencing reasons. It does have the most opportunity for lighter sentence in federal court, and it's far from light in the way that the sentencing code works and the way the guidelines work. But then once we get down and break it further, we're talking about two overall main categories, which is non-production offenses and production offenses. And it is very important to understand the differences and the nuances between these two types of offenses, and the way that the guidelines, the sentencing guidelines, work when we're talking about non-production and production offenses, mostly even further the way that the non-production offenses break down. Okay, when we're talking about the guidelines, it's 2G 2.2 for non-production offenses and 2G 2.1 for what's known as sexually exploiting a minor by production of sexually explicit visual or printed materials. That's basically production. Okay, production is not as common. It is much harder to defend for the purposes that we're dealing in federal court. The mandatory minimum sentences for production are outrageous, just as they are for non-production. Now, one could say that maybe in production, we're talking about production, really what we're talking about is actually creating child pornography, not possessing it, not sharing it. Very often, individuals who are charged with production are also charged with possession and distribution, sometimes receipt. But production, we're talking about the individual is alleged, our client is alleged to have actually either himself been the subject of an image where an alleged explicit sexual conduct is occurring with a minor, or they were involved in the creation of child pornography, sexual exploitation materials, or child pornography. I mentioned here at the bottom the 2012 Child Pornography Report and the 2021 updated report. These are extremely, extremely important. They're available if you go to the United Sentencing Commission website. You can read these reports. The reason these reports were created in 2003, and this leads us kind of into just the myriad problems with the federal sentencing code as it relates to child pornography offenses. Because in 2003, there was an act called the Protect Act that was passed. What the Congress, lawmakers, and judges were seeing was that the laws related to child pornography were not keeping up with the technology that was beginning to boom in the early 2000s. So what they did in 2003 is there was a massive nationwide among lawmakers, judges, defense attorneys, prosecutors, politicians to reform the entire child pornography sentencing structure. They came up with the Protect Act. That is what creates all of the guidelines that we fight against today in child pornography, sexual exploitation, material cases in federal court. Here's the problem. This act, these guidelines were created in 2003 because the technology was just growing. Now, okay, and starting in 2012, when they made the child pornography report, which is available online, you can reach out to me for a link to it. If you can't find it, I think I'll be able to screen share on here as well to show you what it looks like and how to find it towards the end. But in 2012, all these same lawmakers, the judges, defense attorneys, prosecutors got back together, human rights, civil rights organizations, and said, look, it's 2012 now. Everything that you did in 2003 when you created the federal sentencing structure is now too harsh, because technology has now gotten to a point where when you created certain enhancements, like there's an enhancement to this day for +2 points on your guidelines, on your potential score and your punishment in federal court for use of a computer. In 2003, that might have made sense, because prior to 2003, distribution of child pornography might have been mailing pictures and images to individuals that you bought at an illicit store, or that you obtained from other matters not involving a computer, and you mail. But when the boom of the internet, it's like, okay, at that time it made sense. We have to punish people because we don't want people using these new fancy computers to distribute and to possess child pornography. Now it's become the opposite. Now the huge problem with these same individuals, these same groups of people who, other than defense attorneys, because we never agreed with the Protect Act, but the same groups of individuals who supported it are now coming back and saying, look, we're giving people, defendants are being hit with these massive guidelines that made sense in 2003 but don't make sense anymore. And the 2012 Child Pornography Report, it's called, authored by the United States Sentencing Commission, did find that the 2003 Protect Act guidelines and sentencing structure is extremely out of date, and it's bad. And 2012, then we get to 2021, where an updated report was produced. What has changed since 2012? And nothing has changed. This is something that we fight about as defense attorneys who do this. You have to be aware of this for your clients, because it's a huge part of every aspect of the case. There is no other federal offense, nothing even close, where there is so much litigation about the policy behind the sentencing structure itself and the guidelines, especially the mandatory minimum sentences that the Protect Act created for distribution and receipt offenses of child pornography. We're talking about 5-year minimum, 20-year maximum. If you have any criminal history, that goes up to 15 years minimum and 40 maximum. I mean, these are huge, huge penalties for crimes that usually statistically, which these reports break it down for you, but I'll tell you generally, involve first-time offenders and involve very good people. I mean, we at our firm believe that all of our clients are good people. We help good people when bad things happen to them. We've worked extensively in child pornography, sex crime cases, more than any case, with forensic, psychosexual, neuropsychologists to form evaluations for us about what causes a person to engage in this behavior. And what we're finding is it's not that they just woke up one day and said, hey, I'd like to look at child pornography. There are underlying traumas, okay? There are things from childhood that were never addressed. There are legitimate mental illnesses recognized by the DSM-4 and DSM-5. Pedophilia, it's not something that people ask for. It's a disease. And these guidelines are so harsh and don't take that into consideration. Now, 3553 of the Sentencing Code, which we have another federal CLE on federal sentencing in particular. I've made YouTube videos about it. You can reach out to me about how the code works. It basically allows someone to be viewed as a human and consider these things about their nature, which they take into account. They're so important to know in these guidelines that were created by the 2003 Act and today are simply draconian and archaic, have not been changed. We as defense attorneys have a responsibility to fight to change them, and that's what we're going to do. Okay, so going into child pornography non-production offenses, the main ones we're talking about is receipt, possession, and distribution. Okay, and these are the general categories because these are how the guidelines consider what the appropriate penalties are. There's about 7 different statutes within 18 USC 225A2 and 225-2A that describe each statutory penalty and the minimums and maximums. But at the end of the day, receipt, possession, and distribution is how the courts and how practitioners, deal with these cases. So going back just a bit, child pornography is defined by federal law as any visual depiction, including photograph, film, video, picture, computer-generated images of sexually explicit conduct, and that's in person, involving a person under the age of 18. Now, sexually explicit conduct is actual or simulated sexual intercourse, bestiality, masturbation, sadistic or masochistic abuse, lascivious exhibition of the genitals or pubic area, and which is done so in a lewd or lascivious manner, okay? And just to keep in mind as well that these videos and these images that we deal with do not have to involve an actual sex act. It could be a display of a minor's private parts in a lewd or lascivious manner, which is one of the things that we attack on these cases very often. So primary types of non-production offenses, okay? Distribution and receipt. Both carry a 5-year minimum mandatory. That means that if you're convicted of distribution or receipt, then you are doing at least 5 years, and the judge doesn't have discretion to do less unless you do something called substantially cooperate with the government. Less than 2% of federal child pornography cases result in substantial assistance. I did have a case that had one because my client was kind of unknowingly involved. He was charged with distribution and receipt and possession, and he was unknowingly involved in a very large organized ring of mass child pornography distributors in Philadelphia. This was a case in Southern District of Florida where my client resided. We're talking about millions and millions of images and videos that a group of individuals in Philadelphia were distributing. And my client had the opportunity. I was able to speak to him from the initial interview, review the filings quick, get to the prosecutor quick and say, look, my client actually here, even though he's facing a minimum mandatory, does have the ability to cooperate. And he was able to beat his minimum mandatory because he gave consent to the federal government to use, prior to him being charged, to use his identity. And then they went on using his identity and continued building their case against these individuals and across in another state who had a nationwide operation, and it worked out phenomenally. But that's very, very rare in child pornography cases, where mostly we're dealing with most commonly someone who's involved in a peer-to-peer network, such as LimeWire or the equivalents, and other common peer-to-peer sources that are out there. Dealing with the dark web is common. Certain apps, there are mega, and a lot of apps that you'll see. I'm not going to go into every single one here. You can message me if you have questions about that, or ask questions about what are the most common apps or electronic types of devices that we see where people are exchanging or possessing. Peer-to-peer we'll focus on, because that raises particular concern when it comes to child pornography. So again, the reason why we focus on receipt, possession, and distribution is really because of how draconian and how convoluted the guidelines, sentencing guidelines in federal court are when it relates to them. For example, just as one example, the base offense level in the federal sentencing system, you have sentencing guidelines. Base level starting points for possession is 18. Starting points for receipt or distribution is 22. But if your receipt did not involve distribution, you get 2 points off. There are specific enhancements for distribution built within receipt and distribution. We've tried as defense attorneys, and keep trying on your end. I'm going to keep trying. Our firm's going to keep trying to argue that this idea of including distribution enhancements within a crime of distribution itself is, if not double jeopardy, draconian. And the government has found many ways, case law that has been created to get around that by making the statutes themselves in the sentencing code and in the United States Code, very, very broad. But it's pretty awful what happens here. So especially when it comes to distribution offenses and the way the guidelines work, with the technology that we have today, there's so much questioning. I litigate so much. Our firm does. Other lawyers who really just can't stand and feel passionate about what is happening to individuals who, with child pornography federal cases, are facing worse sentences in a lot of cases than people who commit very violent crimes. Not that they're still not good people. All of our clients are, as I've said, but just is shocking in a lot of cases. So, for example, in distribution, the item being distributed in a distribution case, a matter of child pornography, has to be available to someone other than the person who sent the materials. The individual, our client, has to be aware that he was, if using a peer-to-peer network, was sharing this folder, which is a whole other matter in and of itself. When you're dealing with peer-to-peer, I could do a whole presentation on peer-to-peer and the technology behind it. If my client is using a peer-to-peer network and does not realize that his setting on LimeWire, whatever similar network he's using, is open, and he downloads a file that he or she downloads a file that is adult pornography, 3,000 videos or images come in, and there's no obvious indicators like hashtags saying, prepubescent female, torture of minor, things along these lines that would just make it much more obvious that this was, in fact, someone, even if they're using a peer-to-peer, you have a hard argument at trial to say then that, oh, they didn't know that this was, in fact, child pornography when they received it. That becomes a little bit tough. Number of files, the file names, baby. There's some horrible things that we see, baby, anal, rape, young girl sex, things along these lines. Makes it a little harder to say that. But then you also have to go and you have to see, can the prosecutor actually get this evidence into a courtroom in the first place, which is a whole other topic. So again, federal sentencing and non-production cases, it's very difficult. What we need to concern ourselves, most importantly, you need to understand the guidelines and the enhancements very, very well and very clearly. But what we're generally talking about, without getting too specific with the numbers and everything, is what about the images and the videos can kick in certain enhancements, okay? The quality in the image of the videos, the age of the victim or the alleged victim in the video, gender, okay? How child pornography received, what method was it received, what method was it distributed, where was it stored, was it concealed in a sophisticated manner, because there's really, I would say, these 6 enhancements that apply every single case, which makes them all the more draconian that we have to fight against as defense attorneys. The primary enhancements from the guidelines being a victim under the age of 12 or prepubescent, whether distribution occurred and to what level distribution occurred, whether the images included sadistic or masochistic acts or violence, or the exploitation of an infant or a toddler, okay? All of these things, these categories, the defendant engaged in a pattern of activity involving the sexual abuse or exploitation, the defendant used a computer, the offense involved a certain number of images. These 6 enhancements to sentencing are found in over 78% of all federal child pornography cases. Why is that? Because the feds picked it up in the first place. And when the feds pick up a case, it's because they want to know that they're going to hit all of these aggravators. It's a fact, okay? We've learned it from prosecutors. We've heard judges mention it. It's in legal writings. I suggest that the guidelines itself are regarding child pornography offenses. It's probably about 40 pages long, so I can't go into all of them. There is a significant amount of case law regarding when these guidelines should apply and when they don't apply, which we can go into. You can reach out to me separate. You'll have my information. I have a lot of resources, all of the case law on how to challenge these guidelines. A very common one that we challenge is, can they actually prove that the victim was under 12? How do they do that? We make them bring in an expert, okay? Was the focus of the video explicit sexual conduct, okay? Or was it child erotica, which is also a nude image of a minor, but not in a sexually explicit manner. Now, the base sexual explicit manner that the government says and the statute says is a specific focus on a unnatural specific focus on the genitals is basically the bare threshold for a child pornography offense. But sadistic or masochistic act, that guideline or that aggravator, there's so much cases about what constitutes sadistic or masochistic, which is basically causing pain or torture. The courts have kind of killed defense attorneys on that, but we still fight it. They basically said that any infant, anyone under the age of 12, but especially any prepubescent minor who is being vaginally or anally penetrated, it is assumed that they are suffering pain. But there is case law to the contrary as well. Again, we don't have time to go through all of it, but each of these guidelines, you have to, even though they're so common, you have to argue them. You have to argue that if your client is charged with possession, then why should he get a distribution enhancement if he's not being charged with distribution? Okay, now you want to be careful about that, because then you don't want the prosecutor to go back and say, well, I'll just charge him with distribution. There's so much convoluted aspects of this that you just really need to pay really specific focus on and master the guidelines. And I'd be happy to provide you with those materials. As far as production offenses go, I'm not going to spend too much time on them. Production offenses carry a mandatory minimum term of 15 years, a max of 30. If there's any prior convictions, we're talking then about 25 minimum years day for day and a maximum of 50. And then if we have a third offense, we're talking about 35 years as far as a minimum and life in prison as a maximum. Production offenses are very, very serious. You want to understand the nuances and the guidelines that are associated with production offenses because these cases are tough. They're serious. You want to set expectations in these cases with your client very soon, but there are absolutely defenses to production cases. There are situations where the government may say you induced child pornography by having a video and taking a screenshot video, an image of child pornography. We fight that. Okay, we fight that. There are things to fight here. You just have to know the nuances, know the guidelines, and know the case law very well. So the stages of a federal child pornography charge: you have the investigation, the charging, similar to what the previous aspects of the program, the CLE, has discussed. The sentencing, obviously, as we said, is the most unique. The way that these points, these extra points, depending on these aggravating factors, come into play and how you fight those. I think probably the most important thing to consider with this is that sentencing disparity, this is federal, okay? No one's going to really fault a judge in Iowa from giving probation for a child pornography case when a judge in Florida might give in state court 5 years. Iowa and it's Florida. Federal is supposed to be standard, okay? Sentencing disparity is a huge aspect of federal sentencing. So that's where, and if you read these numbers, if you read these reports that have the statistics that I advise that you read, the 2012, especially the 2021 report offered by the Sentencing Commission, you'll see that individuals who get charged with possession but have the same exact, ultimately the same guidelines as receipt minus the minimum mandatory, the amount of sentencing we're seeing across the country, even in possession, simple possession cases themselves, literally range from 0 days in jail to 270 months. Okay, these are massive discrepancies. When you do a federal sentencing in a child pornography case, you have to be prepared to argue the disparities. Cases from what that judge has done, it's all on Pacer. Go out there, find the cases in different courtrooms with similar facts. I have a long list of cases for the Southern District of Florida. I'd be happy to provide it to you if you want to email me. Probably about 50 lists with the standard possession, distribution, receipt kind of usual fact pattern, usual guidelines, and the disparity in the cases that we're seeing. The judges are recognizing this because variances from the sentencing guidelines, from what the guidelines in the United States Sentencing Commission recommend sentencing to, a judge to give a sentence to. Variances are very common, more so probably than any other federal offense, because there is so much policy, there's been so much debate, it's still ongoing, and judges know that because they're involved in it. When they're thinking, every case these days involves 600 or more images or video. Each video, by the way, constitutes 75 images. Okay, so if you have, I think, 8 videos, you've already met that, and then you get 5 additional points on your sentencing guidelines. The judges know this. You have to be prepared to argue at sentencing the draconian nature of the sentencing guidelines. As far as plea negotiations in federal sex crimes, and specifically child pornography, you want to always try to get a plea to possession, because it does not have a minimum mandatory sentence. Please go for possession. Receipt, distribution are very similar. The guidelines change a couple points, but possession is where we think far more than it ever should be for a majority of these cases, especially given the circumstances. If it was a peer-to-peer network and the individual didn't realize that this file they had that they thought was adult pornography included child pornography, and then the feds are using their software, I believe it's called Mole or eMole, where they go on and they just look through these files and say, oh, this file has child pornography in it, and this is the IP address, we got them. It's not right. It's not right. So common defenses of federal child pornography cases, peer-to-peer networks. You have to understand the nuances and the way, the technology behind peer-to-peer networks and how they work. You really should have an expert to do this if this is one of your first cases. Experienced attorneys like us understand how peer-to-peer networks work very well. It is a defense to a federal child pornography crime if you possess less than 3 images or videos, and or report right away to law enforcement that you accidentally came upon these videos. Pretty rare, but it does happen. Lack of intent. That goes back to a lot of what I'm talking about with peer-to-peer, which is the big point of debate now. People can get big files, and if the evidence doesn't show that the file is so obviously containing child pornography, they receive it on accident. They clicked on a website and saw that it was not, it was child pornography. It was not what they were looking for. They did not intend to receive child pornography, because for a receipt under that statute, you actually have to have specifically intended to receive child pornography. Make sure that's something that you always defend. It's not like possession, where just being in possession of it can be a crime, as long as they can prove that you knew, or should have known that it was based on circumstantial evidence that you possessed child pornography. But receipt, specifically requesting it, make sure that you challenge that. Like in all of the cases we talked about, misconduct by law enforcement, issues with the search warrant, issues with the cyber tip from Google, or issues with the tip and the information that NECMEC received, very important. Attacking the technology itself, Cellbrite, the software, GripEye, these softwares you'll hear about that the government uses to process, if they get somebody's phone and they do a phone dump, see if there was issues with the service. You have to do an evidence view in these cases. You have to go to law enforcement, to the FBI headquarters, wherever it might be. In South Florida, it's Miramar, and say, I need to see these photographs, And more importantly than the photographs, this is the biggest tip I could probably give you. So many attorneys, say federal attorneys, will go and say, let me see the photos. Oh my God, there's babies being anally raped. My client is screwed. No, that might make out enough for an aggravator. So when you go to see the images, is it horrible? Yes, of course. Get a different job if you don't want to go and deal with this. You need to fight with your client, or don't take the cases. When you go to do the evidence view, you need to see the photos to the extent. What I do when I go, I say, please create a separate file, okay, where you can show me how, based on the photo, you would meet each one of the enhancement. Torture, this is that photo. Okay. Prepubescent, this is that photo. Thank you. Show me the photo that led to the warrant or led to the cyber tip. Is this sexually explicit conduct for me to see? Yes or no? Thank you. I've seen that. Okay. You don't need to go and see all 1,000 videos. What you do need to see and what needs to be provided to you is, of course, all of the reports, the search warrants, the complaint, transcripts of any conversation that were alleged to have been from an undercover with your client engaged in the distribution or agreement to provide child pornography to an undercover. Get transcripts of those reports. But really, more than anything, what you need is you need the government, whether it's the FBI agent or the prosecutor there, to show you what's called the sanitized pathways. Sanitized forensic report. Not enough lawyers do this. Because the prosecutor won't go give you this right away if you don't request it. They won't. They'll say, come view everything, and you've gotten your evidence view. But what you need to know is you can request, and they have to be able to provide what's called a sanitized forensic report. And this is the report that the agent, or if it's a state detective who's part of the ICAC unit, the report they generate, okay, that shows the pathways. It shows when the video was on the computer or the phone. When was it opened? Was a thumbnail created? Okay, was a bookmark created? What happened to the video or the photo? Was it deleted? Was it sent somewhere else? Was it put in a different file? Where are these photos moving to? They can't give it to you with the alleged child pornography itself. That is distribution of child pornography, and then the attorney is charged with receipt. So that doesn't happen. But they can give you the exact same report that you need, so you can see, can they actually link these photos to your client's, to my device that they have seized or that my client voluntarily gave them? Can they link these photos to that device? Okay, that's super important, and you can have that recovery. If you have to go see the images, which you always do, you see the ones you need to see, you see them show you that there is either how many videos and images there are, if they can meet out their 600 or more enhancement sentencing guidelines, so you can tell your client, yes, I did go look and I saw they had more than 600, okay? But get these sanitized reports, get what they have minus the images, they will give it to you. If you have questions specifically how to get it, email me, call me, and call my firm, and we'll tell you exactly what you need to be looking for. But challenge the IP address. Find out if someone else was living in the home that could have accessed this. Was somebody else mooching off of our client's internet? The feds are very good at tracking an IP to the person. Of course, if your client gives a statement, that's another story. And very often our clients this will be their first offense, and they will say, yeah, cops came and they just showed me some photos and they asked me if I had seen them before, and I said yes. So I was terrified and I thought they had me, and I told them yes, no one else uses my computer or my email address. So same as any federal criminal defense, always best case scenario that either your client doesn't give a statement, or if you can find grounds to suppress the statement, you always have to try that. But the software that they use, Cellbrite, which does the phone dump, and then usually GripEye, which the lead agent then uses to narrow down their cell phone dump to what they're specifically looking for, the specific videos or images or hashtags. You can get that without the images, and you really have to. So online solicitation of a minor is another charge that we see. 240, 2422, 2423, illegal to use the mail or internet, any form of interstate or international communication to solicit a minor for sex. It's illegal to travel across state lines to meet a minor for sex. One nuance about that, these are pretty straightforward. There are very serious penalties, anywhere from 10 to 30 years in prison, depending on the aggravating circumstances and the priors. Of course, it's more if you created child pornography, if you took a video during this as well. And you can be arrested and convicted for soliciting a person you believe was a minor, even if she was above legal age. It's about what you believed and what the defendants, our client's intentions were. Okay, there are certain rules, though, when it comes to these offenses regarding solicitation, and enticement is another one that carries with it a 10-year minimum penalty, and that's enticing under these statutes, enticing a minor to commit a sexual act, whether it's a federally prescribed sexual act or a state act. One thing to always look out for is you can be mistake of their age. You can still be prosecuted and convicted if it's a officer acting as a minor, if it's law enforcement acting as a minor, okay, or if you believe or you know the individual is a minor. But if it is an adult, non-law enforcement who's on there acting as a minor, there are actually exceptions where that's a legal defense, because that's not allowed to be grounds for this if it's not an actual minor you're talking to yourself. So a couple defenses, there's a lot of defenses to even just to know the guidelines as they relate to these. Human sex trafficking, not that common, but definitely still important. These are situations where adult individuals are coercing, manipulating, whether through force, coercion, as we said, recruiting, manipulation, in order to provide sexual services, either to themselves, but more commonly to other individuals in order to benefit our client or the defendant. They carry with it minimum mandatory sentences that can be very severe, depending on the number of convictions, depending on how much fraud or force was used. That's another one that we see commonly, and you have to know the nuances. Again, for example, if the prosecutor is able to prove a defendant just played a role in preparing to send a sex trafficker in the United States, they could face a sentence of 7 years. Okay, so you can argue, if you feel that the evidence is overwhelming, maybe your client was not, didn't fully complete this. There's kind of an attempt situation here where it's going to result in the full possible sentences that you can face. So again, trying to cram in as much as possible here. The federal sentencing guidelines, federal sex crimes are so nuanced. Reach out to us, read these reports, go on to the sentencing guidelines, type in United States Sentencing Commission reports. There's so many resources there. I still rely on them all the time. My clients, it really, really helps. And you have to do this early on, because these are not your typical state cases where it's 5 years for a third degree, 15 years for a second degree in Florida. These sentences based on the guidelines can vary so greatly. There's so many minimum mandatories, and you have to understand this so you know how to attack these and fight for your client. So that's it for federal crimes. I believe that now we have a bit of time left. Again, use our QR code, reach out to me to discuss the nuances and discuss how to fight these cases and deal with federal prosecutors in sex crime cases. And I believe the plan now is that we're going to invite all of the attorneys back for a roundtable discussion.